we have seen there has been a communicating a name, a proposed name of the Honorable Professor Kithure Kindiki as the nominee by the President to replace the Deputy President, then Rigathi Gachagua, in the office of the Deputy President of the Republic of Kenya. So there are a number of constitutional concerns that arise or follow from that. The Constitution requires that a person nominated for the position of the Deputy President or the President under Article 137 of the Constitution must meet certain requirements. And at the very least, he must not be a state officer. Professor Kithure Kindiki, as we know as at now, he's still serving the Republic of Kenya as the Minister or the Cabinet Secretary in charge of Interior Security. So we are calling the court to quash, or rather to declare as unconstitutional, the appointment of Professor Kithure Kindiki as a replacement of His Excellency Rigathi Gachagua in the office of the Deputy President, as he is unfit, he is unqualified, and he does not meet the threshold that has been set under the Constitution of the Republic of Kenya.
Today we have filed a petition before the High Court at Nairobi, in which we are seeking, we are challenging the process under which the impeachment of the Deputy President, Honorable Rigathi Gachagua, was conducted by the Senate yesterday. And part of what we are challenging is the manner in which the process of impeachment was done. And we are saying that the Constitution is the grundnorm and it has to be respected. Anything that is done under the Constitution has to be done within the processes that have been prescribed by the Constitution. Any political interferences, political play must not be evident, because it then befits what the Constitution intended for it to happen.
Once there is a vacancy in the office of the Deputy President, the Constitution says that within 14 days, go on.
Once there is a vacancy, and that vacancy is not declared by the Speaker, it is declared by the IEBC commissioners.
What?
The vacancy of a Deputy President is not declared by the President nor the Speaker. It is the IEBC's mandate. Once it is declared, the President has 14 days to nominate a candidate.
Wait, let's pause there. So even in the event of death, it's the IEBC that will gazette the vacancy?
It is them who declare.
Why? Where does it say that?
I can't be carrying the Constitution here, but under the IEBC Act, that is a preserve of the IEBC under the IEBC Act.
To declare vacancies.
To declare vacancy. The Speaker will gazette.
Writs.
They will gazette. The IEBC will declare that this place is now vacant. The President, within 14 days, shall nominate a person. That person's name shall be moved to the Speaker of the National Assembly. Within 60 days, that name shall be discussed. And if approved by 2/3 majority.
It doesn't say that in the Katiba.
It might be my Constitution I'm reading, but that is the law. It must be taken to Parliament. Parliament has set a precedent that any matter being discussed, public participation is required. Any matter being discussed. So which means we are going to go to public participation. And this time, the question that will be there during the argument, you heard my good lawyer, Ongoya, ask, is public participation restricted to a county? Deputy presidents are elected at the polling station. The presidential polling results end at the polling station. So people will be going to court saying public participation should be at the polling station. That is the whole issue. But the journey is long. Those who listened to Justice Mwita when he said that the 29 cases, we will wait because of the philosophy of Montesquieu of separation of powers, let Parliament do their job. Once they have done, we will be seized of this matter. So the question whether jurisdiction is at the Supreme Court has already been decided. Jurisdiction is at the High Court. After the High Court, this matter, the Court of Appeal is having jurisdiction as an appellate court against the High Court. The Supreme Court will have to sit on this matter. I don't know why people are forgetting. Uhuru and my good friend Baba Raila Odinga started the BBI. It lasted in court 4 years. Wambura's matter lasted in court for 3 years. Elections were done before that determination was done. Mwangaza, the governor of Meru right now, and I was here with you, I told people, Mwangaza will be kept in office until the Supreme Court decides otherwise. Mwangaza is still in office. So this is the trend. If you look at the jurisprudence, for those lawyers who have been following on citizens, the Wajir matter, the governor of Wajir was evicted and swearing in was almost being done immediately. The decision of the court was that reasonable time must be provided for an aggrieved party to go to court to seek redress. So the special meeting that is likely to be held on Friday is academic. And the good speaker, who is a senior lawyer, knows it very well, that any type of shenanigan to try to swear in somebody at night, the Kibaki style at night, that was 2007. Kenyans moved away from that.
That's done.
And it is now the 2010 constitution. Transparency, openness, where people are involved. Let us see this process, how it goes. It is very bad music for those ones who wish Gachagua is hounded out unconstitutionally. But they are charging him that he breached the constitution. So it is a double.
Wait. Ile hasira niko nayo. Ile hasira niko nayo ya Gachagua, na goja mtu anichokoze ajue mimi ni shetani. Mtu anichokoze leo ni muue. Wajaluo, kumbe mnasikianga machungu hivi. Na mko na roho nono. Mimi nasikia kupasuka. Hasira ya mulima, mushaguza mulima, mumeeka kidole mulima, mumakaimpeach mulima, nasikia niko na hasira. Na nyinyi mumefanywa hivi mara kadhaa, na hamjai kufa, na hamjai hama Kenya, enyewe Wajaluo mna roho. Saa hii nikakushika na hizi mikono zangu za ugali na kukula na meno. Hasira niko nayo ya mulima.